That has to do with the fact that we're not looking at chemical entities anymore, but we're looking at monoclonal antibodies, proteins, peptides, nucleic acids, and the like. And these biosimilars, for you if you're a generic Indian company and you want to enter the market in Germany or Europe, they are a completely different ballgame. And in these cases, you do have strategies, which I heard earlier today, called evergreening or the like, but which do not employ the more traditional means of prolonging your patent protection, but employ very standard patent applications due to the fact that the regulatory process for biomolecules, so-called biosimilars, is much more stringent, much more complicated than it is for mere bioequivalence in the field of chemical entities. So if you look at this picture again here with this extra curve of return on investment, in these cases, you can actually possibly extend, we have cases like that, extend basically your patent monopoly, not with the traditional SPC, which we will hear about, but for example with patents relating to the glycosylation pattern of something, the method of production of the protein, because these patents with the novel kind of entities we're talking about play an important role as the regulatory process provides for that the generic uses the same method of production that the innovator used. So what I'm trying to explain is in these cases, minor, you may say, minor patents relating to producing a protein can be very important and can actually give you a monopoly, which previously, of course, in other cases for a chemical entity, this was not so dangerous. So what we're going to go through is I will explain a little bit the process of how litigation works in Europe and in Germany. I will show you some slides on where it usually typically takes place. And then we'll go a little bit in more detail of if you were confronted with patents by your competitors in Europe, what I would suggest you do in the form of an opposition proceeding before the European Patent Office. Now, what, of course, we as German patent attorneys like to stress all the time, we do this frequently coming when we go abroad, is the fact that litigation primarily and only takes place in Germany. And the reason for that is obviously we would also stress this fact is that the system works so well, right? I think it also has cultural reasons, but if the UK simply has a very different legal system than we do, so they have a completely different system with solicitors and barristers, and you will understand this much better than I will. It's also more costly. We will look at costs in a moment, but 6,700 litigation cases in Germany versus in France 1,000, in the Netherlands a few hundred, and in the UK a few hundred. So, and today I will not talk about the Unified Patent Court, which will obviously come someday, we believe, but I will talk about the existing system because it's a very well-working system. So most of litigation actually takes place in Germany, and the enlightening fact is that if you look at the first line here, the infringement decisions are actually not as high as one would typically think. So only in 22% German courts decide that there's an infringement. What is a little bit disturbing if you look at this is that you would expect the French and the Dutch and the UK court to have similar numbers, but they don't. So maybe there's a reason for a unified patent court if Germany and France differs by 15% when it comes to deciding on infringement or not. But what is interesting is the amount of revoked patents is fairly low. And this figure here is the nullity proceeding, which I will talk about in a moment. So in nullity cases are fairly low. 50% of the cases, 46% actually get settled. If you look at the timeline, so if you're sued for patent infringement in Germany, the whole thing is very quick. 1 year and you have a first instance decision about. What's also very interesting is in the United States, by the time you have a decision in Germany, in the United States, you probably would not have even fulfilled the discovery process. So it's very effective, it's very quick. And we know, in contrast to other countries, a so-called bifurcated system, a system whereby the question of infringement, does the party that is sued for patent infringement infringe or not, is decided in a civil court, in a district court, whereas the question of validity may actually not be touched by this court, is decided by, for example, the European Patent Court, Patent Office, and later, upon the Patent Office, when it's finished with all its first and second instances, for example, in Germany, the Federal Patent Court. This bifurcated system was, just to mention it, imitated a little bit by the unitary patent court system we will have. So you will have a nullity process that can be independent of the litigation. So you kind of know a little bit how this litigation works now, so you know the numbers, but you don't want to go there. Obviously, you don't want to get sued for patent infringement, right? So some advice on what to do if you're a biopharmaceutical company or you're a generic and you want for the first time to enter the market in Germany and bring your product there. Do you have a freedom to operate analysis? Now, my personal experience, FTO is not FTO. Number one, you would like to have a very good search entity do this, and not every entity can actually provide you with a very good search. Searches for granted patents in the field of biosimilars involve obviously also looking for DNA and protein sequences in special sequence databases. As you pharma people know, many of the patent claims in this field involve sequence similarity, so the claims can be much broader than the mere sequence that is claimed in the patent, which means you need people to look at these things, whether or not infringement is given, that really know what they're doing. If you've come to the conclusion you have freedom to operate, then you could actually, of course, enter the market. The other option, of course, is you come to the conclusion you do not have freedom to operate, or at least there are questions about whether or not you have freedom to operate. Then the alternative could be in identifying whether or not you want an early market access, could be the potential invalidity of the patent. If the patent, however, is potentially invalid, it is a priori there. It's your assumption that it's potentially invalid. So you have to provide for measures actually to ensure that when you enter the market with your product, you don't get, for example, a preliminary injunction and you need to take your product off the market immediately. What a patentee in various different technical fields typically does, let me say in the field of engineering or maybe food, which I also do a little bit of work in, is they would maybe send a warning letter or an information letter. I promise you, in the field of pharmaceuticals, where the monopoly is the principle and the license income is not the principle, that is typically not a tactic. So the warning letter and information letter is not something I would expect you to get from a large pharmaceutical entity in instances where they are providing for and trying to attempt to monopolize and ensure that their drug is the only drug on the market. But if your scare, your problem is, well, I will not get a warning letter, and I will not get an information letter. I could get actually a preliminary injunction. Then what do you do? Few systems, actually, countries in Europe, Germany, Holland, Belgium, and luckily also the new Unitary Patent Court, know what is called a protective letter. And this is, of course, exactly what you want to do in the case where you enter the market with a patent which you think is invalid. So what does the protective letter do? The protective letter is a brief that outlines the argument why a patent is invalid. This protective letter would say the patent is invalid because the patent office did not observe prior art A, B, C, and D. And the protective writ or protective letter is sent to the district courts that are typically responsible for the preliminary injunction. And these have to look at this protective writ. The consequence of the protective writ is that you as a party cannot get in your absence a preliminary injunction and be obliged to take your product off the market. So it's a very important tool, and we're thankful that we find this tool also in the unitary patent regulations, or for the unitary patent court, let me put it this way. That was this slide. Now, coming back, I had promised I would give you a little bit of an overview on the costs of litigation in the various different jurisdictions. The German costs are around 60 to 150,000 euros are probably a fair assumption. In some cases, the attack on the patent, of course, would involve more or less effort, and it could be more because you have a parallel opposition or nullity proceedings. But I think the assumptions are not so bad. Apart from the costs, the substantial benefit in this area is really that the whole process is very streamlined. The courts are very professional. They deal with, as I said, I think in Düsseldorf, over 1,000 litigation cases per year. Whereas the courts in the other jurisdictions obviously cannot have this experience due to the fact that simply the numbers are very small. Litigation, however, as I said, is not what you want to do. You want to actually have certainty before you get there. And what's the best thing you can do is you can try to find out whether there's a certainty to the validity of the patent you're looking at that concerns you in a so-called opposition proceeding. The opposition proceeding takes place before the European Patent Office. It's a post-grant attack that anyone can make on the patent. There is, of course, a due date. You have to watch that you don't come with your opposition writ over the 9-month period after the publication of the grant of the patent. But the opposition proceeding, in contrast to the nullity suit, has some great advantages. Number one, of course, this opposition proceeding is for all of the validated states of the European patent. So you're not just attacking the German part or the French, but you're attacking the whole thing. It's a pretty standard process. The opposition boards that handle these cases are very professional. There are 3 technically trained members of the examination division that sit in the so-called opposition division when this attack takes place and read your opposition writ. It's not costly, the fees are fairly low. This is much in contrast to the nullity suit. If you attack the German part of a European patent, you file a so-called nullity suit. This is if you have missed the due date for attacking it on a European level. And the nullity suit, and I've had a few, depends, for the court fees, depends very much on the value of the court proceeding, or the value of the proceeding decided by the court. So if the value of the proceeding is a few millions, then the court fees can be, which I have had, over 150,000 euros. So this is a process you do not want to do. The thing I hear a lot, I've been coming to India now for 12 years or so, and I, of course, meet also industry clients and partners, is, well, what we do is, and it's very cheap, is a so-called third-party observation. This is something which you can do where the patent is still in the examination process and you want to get rid of it, and you basically say, listen, patent office, I have prior art, you have to read this prior art. And this prior art will tell you that you should not grant the patent. My personal opinion, probably because I've done so many opposition proceedings and of course observed others where third-party observations were going on, is it's not the right thing to do, primarily because you're not a party to the proceeding. You cannot argue in these proceedings, and that's very dangerous, because if you then do decide to enter the market and you have your invalidity assumption of the patent, but you filed third-party observations, there's a certain likelihood that in a nullity proceeding or in any other kind of invalidation act, your prior art will not be considered as very relevant because it's been used, and the Patent Office has looked at it, and the Patent Office has decided it's not relevant. So any person can file the opposition. One of the most important aspects of it is that the straw man can do this, and this is something you should really look at. If you're a mid-sized or smaller company based in India, you can file an opposition without saying you are the opponent. You can have me, or you can have any of the members here on the table actually do this. So that's a very, very important tactical aspect. I see I'm running a little bit out of time. The opposition fee is actually not very high. You have to identify the opponent, which can be a straw man, for example, and you have some formal, but however, very many substantive requirements. The nice thing about this process, unlike litigation in the United States, the validity in this process is only decided on novelty, inventive step, and enablement issues. Of course, also Article 123.2, but that's, while it is very substantial issue in true real proceedings, let's stick to the more important novelty and inventive step. In the context of pharma, I just want to mention that, of course, there is special case law. I promised I would not talk about pharma case law today, but that has to find its application in attacking patents. These are case law relating to dosage regimens, to patient groups, to selection inventions, to special provisions you have in the biotech arena. But as long as the attorney you work with is firm in these areas, the opposition process should run fairly smooth. The substantive examination takes place based on the writ that you provide for. What is very important is that at some stage you cannot provide for new grounds.